This is National Popular Assembly meeting, and tonight's class will be Class 2, which is Law History, and tonight we'll be reading from a document written by John B. Nelson, and this gentleman put together some very, very good information about what has happened, and he called it a declaration of cause and necessity to abolish and declaration of separate and equal station. Basically what he's getting at is that the differences between the Republic and what's been going on in the corporation. And so to start, I'll just start reading, and I'm going to stop and start where it's necessary. And what I've done throughout the document is that I have outlined many of the dates in red so that they stand out, so you can kind of keep track of it. I have also taken all of this entire document and I have incorporated it into my timeline doc, and you can find both of those docs in the Class 2 documents under the meeting rooms. So if you want to follow along, you can do so. So I'll just start. So I have enclosed Senate Report number 93. There's a lot of numbers in here, so I'm going to skip some of the numbers. So this particular Senate Report, Summary of Emergency Power Statutes, consisting of 607 pages, which I believe you'll find most interesting. The United States went bankrupt in 1933 and was declared so by President Roosevelt by executive orders, so on and so forth, and by executive order on March 9th, 1933. See the Senate Report, corresponding Senate Report, under Trading with the Enemy Act, 65th Congress, so-and-so session, 1917, as codified in 12 USC A 95A on May 23rd, 1933. Congressman Lewis T. McFadden. Now that's a very important gentleman. If you really want to learn everything that happened in 33 and some of the outrage, and that there were men that were well aware of what was going on, find the congressional record of Lewis T. McFadden and read it. It is a stunningly interesting good read, and it is necessary for everyone to understand what happened then and the consequences of that and what is happening now, as to the whole global reset, as to the gold bill. All of this stuff happened back then. But that read, the congressional record from Lewis T. McFadden, is extremely important. So, okay, so what did this gentleman do? He brought formal charges against the Board of Governors of the Federal Reserve Bank system, the Comptroller of the Currency, and the Secretary of the United States Treasury for criminal acts. Those are also still able to be found. I do not believe I have a copy of all of what was just spoken of, but I do believe I have some of it. The petition for articles of impeachment was thereafter referred to the Judiciary Committee and has yet to be acted upon. See congressional record. Okay, so there you can go get the congressional record of it right there, and you can track down the charges. Congress confirmed the bankruptcy on June 5th, 1933, and impaired the obligations and considerations of contracts through joint resolution to suspend the gold standard and abrogate the gold clause. June 5th, 1933. See corresponding joint House resolution 192. And that's, of course, what these people that are trying to do things in commerce or with the law merchant, they always say, well, as per, House Resolution 192, I don't have to pay you because there's nothing to pay with. Are they wrong? No. Does it really get them anywhere? Also, no. The trouble with how they could do all of this was, you have to remember that the Town and Maternity Act, the Federal Reserve, and all of the registration of all of the property, meaning everything from our bodies to the people that were registering our, the land back then, the governors came together and then did the governors meeting, okay, which then pledged it all to these idiots. So it doesn't, if you're sitting there as an infant, what I'm getting at is that if you're sitting here as an infant, it doesn't matter the fact that they're not giving you anything to pay with. Of course, they won't. They're going to give you monopoly money to play with because you're an infant. However, once you claim your estate, that's a whole different matter. So once you go through the VSOF status docs and claim your estate properly on the public record and correct the public record as to your status and your relationship to them, then that's different. Then, yeah, they would. You still wouldn't want to try to make them pay for things, because then that's taking a benefit from daddy. What the status docs do is rip everything out of daddy's hands and say, you're no longer my father, and throw him back into the ocean from whence he came. Let him swim back to England. But anyway, I digress. To continue, the several states of the Union pledged the faith and credit thereof to the aid of the national government, and that's what I was talking about what the governors did, and formed numerous social committees such as the Council of State Governments, Social Security Administration, etc., to purportedly deal with the economic quote-unquote emergency, which of course is the bankers caused. These organizations operated under the Declaration of Interdependence of January 22nd, 1937, and published some of their activities in the Book of States, 1937. That's also a very interesting book, the Book of States. Edition of the Book of States openly declared that people engaged in such activities as the farming, husbandry industry had been reduced to mere feudal tenants on their land, which is exactly why a lot of the riots and various different things happened during the Great Depression, when wave after wave of foreclosures came over, because those farmers that they hadn't yet registered their land, registered their deeds, and registered their allodial titles under the filthy Roman Torrens registry system, they went after through the banks, okay, so that they could grab everything, so that no one was any longer having a allodial title or under the system of the auspices of what the protection of a allodial title gives you. So to continue, the Book of States, 1937, page 155. This, of course, was compounded by such activities as price fixing wheat and grains, which is 7 USCA 1332, quota regulations, 7 USCA 1371, and livestock production, 7 USCA 1903, which has been consistently below the price of production, interest on loans, and inflation of the paper, quote, bills of credit, leaving the food producers and others in a state of peonage and involuntary servitude, constituting the taking of private property for the benefit and use of others without just compensation. There's another interesting little part of history in here that is not mentioned, and that is the NFO. NFO is a National Farmers Organization. The NFO was one of the most powerful groups in the entire nation, dare I say the entire world, back then. And the politicians were deathly frightened of the NFO, because the NFO could literally turn off the food whenever they wanted to. So communists can't have that, okay? Just can't have that kind of power in somebody else that isn't theirs, right? Can't have that power to somebody else. Nope, not going to have it. The reason I know so much about the NFO is because my grandfather was one of the biggest leaders in the NFO, and made it very clear as to what was going on, and taught people, that basic rule, never trust a banker or an attorney. Well, they didn't know everything that was going on behind the scenes, but they did know a lot of it. And the main thing about the destruction of the currency was one of the biggest things. And so during all of this busting up of power and things, meaning the people's power, the NFO was definitely targeted during this period of time. And it's just important to remember that was this whole thing about attacking the farmers is about attacking land title, is about attacking allodial land and having the capacity to be self-reliant. So to continue, note the Council of State Governments has now been absorbed into such things as National Conference of Commissioners on Uniform State Laws, whose headquarters office is located at 676 North Street, Clare Street, Suite 1700, Chicago, Illinois 60611, and quote-unquote all being members of the bar and operating under a, quote, different constitution and bylaws, close quote, far distant from the depositors of public records, has promulgated, lobbied for, passed, adjudicated, and ordered the implementation and execution of their purported, quote, uniform and, quote, model acts and pretended statutory provisions to, quote, help implement international treaties of the United States or where world uniformity would be desirable, close quote. What do you have there? You clearly have the layout of the New World Order. The members of the bar are always, shall always, be your mortal enemy. That's why the original 13th Amendment was passed. Okay? So, to continue. See such and such reference book, National Council of Commissioners, Uniform State Laws. Okay? That's another interesting read, because they blatantly show you in that book what they're doing. So it's not like this was, hidden. This is apparently what Robert Bork meant when he wrote, "We are governed not by law or elected representatives, but by an unelected, unrepresented, unaccountable committees of lawyers applying no will but their own," close quote. See The Tempting of America, Robert H. Bork. So, again, just to reiterate that attorneys are your mortal enemy, the Bar Association. If we were to end the Bar Association in this republic, everything else would go away. Everything. They wouldn't have anything else left because everything is being administered through the Bar Association. So this association has been engaged in activities such as turning marriage, quote unquote, marriage licensed into international private law through the international liaisons, which met at such places as the Hague conferences. Okay, that's another reason why I tell people stay away from the Hague. All these idiots that are sending documents to the Hague and say, oh, I'm going to put this through the Hague. You're a fool. You have any idea what you're doing. The Hague is also your worst enemy. Okay, and okay, in this country, okay, Thomas Jefferson, Benjamin Franklin, George Washington. These men did not have marriage licenses. They didn't exist back then. They didn't come into existence until after the Civil War. And the reason they came into existence is because they said, if a white man wanted to marry a black woman, then you had to get a license for that, because you got to remember that the slaves went from being private property to being public property under the 14th Amendment. The term was called intermarrying, and it was literally seen as because you were marrying livestock. Okay, not to be racist here, but this, from a standpoint of law, that's what they saw it as. So it was called intermarrying, and because you had to have permission to do that, you had to get a license. And then what they did was they just wrapped everybody else into it later, because no one understood what it was. So, and then what the marriage license does is it creates a third-party contract between you and your significant other and the corporate state, of which then they have interest in the production of what that marriage creates, which is children. Okay, so you're on a breeding farm. All the women out there that are listening to this, you were pimped out a long time ago, okay? And you need to wake up to that fact and stop signing documents of the corporate state. I don't care what they are. You never, ever sign anything that the corporate state gives you, ever. Or an attorney gives you, ever. Or an inferior court gives you, ever. None of it. All of it is consent from your pimp. So stop it. From a standpoint of the marriage license, where do the marriage licenses come from? They came from after the Civil War, when the slaves were considered to be, they were moved from private property to public property. So what happened is that you had to get a license to marry a slave, because they were chattel before, and they just became public chattel. So you had to get a license from the state in order to what was called, quote unquote, intermarry. And that became the auspice of which they sucked everybody else into it later. So that then all the white people kept coming to the corporate state and saying, oh, can we please have a marriage license? And the corporate state said, sure, great. We now became a third-party intervener in between the union between man and woman, and so that we can take possession of and administer the product of that marriage, which is the children. So from that standpoint, the corporate state is your pimp. They are pimping out your ovaries to the commercial realm as your children become products in commerce, as quote unquote human resources. Just like they trade iron and rubber and steel on the stock market, you're a human resource. And the only way to get out of this is to claim your estate and claim your children on the public record and fix the public record. Fix the probate record. They're doing everything, all of this through probate, okay? Which is something else that I'm not exactly sure he mentions in this document. But that's what they're doing. It's under the ancient system of pledging, which I speak about in the class that I covered regarding the Edward Mandel House quote. So
Stupid question here, Zen. Just had a little bit of a thought in that regard. What does that make the pastors and priests and that at churches who administer marriages and request that the license be in hand? What does that say about the frickin' churches at this point?
yeah, the church operates as all of them operate as clerics. Okay, so even this is what most people don't know either. Even notaries even notaries are technically acting as clerics. Okay, so and so is the black robe attorney, the priest of El sitting up on the bench. He's also acting as cleric. So what are they doing? What are the priests doing with the marriage license and all of that? Well, they're all part and parcel of it, okay? Because the bottom of the dirt of all of the problems of this entire planet stem from the cult of Rome. The aspect of those religions of the controlling of people of their minds. So, when the corporate state comes in and controls everybody through that, the church comes along and says, "Oh yeah, you guys are finally catching up. We'll go right along with it too. Now, in order for us to marry you, you have to come in here with a license from the corporate state." Why? Because they're all 501c3 slush fund non-for-profit religious organizations. Okay, the churches are for-profit businesses, but they make it out to be, "Oh, we're non-profit." No, you're not. Stop lying. The Vatican is the biggest corporation on the planet, always has been, and it's the most interwoven thing throughout all of the planet through commerce, and always has been. Rome rules Europe, period, without question.
The Vatican was literally the first central bank.
Yeah, exactly, precisely. Until basically they handed over that power to the Rothschilds, and I can't remember the date, but it's in my timeline, Doc. And yeah, and where did they get that from? Oh, that's right, because the Templars set up all the connections. So what do you have? You still have so you have the church and state. There is no separation of church and state. It's the same religion, and the religion is obedience. The only thing we have, as far as our Constitution is concerned, is that it states that there shall be no law passed, basically saying that you can have whatever kind of religion you want to, and there can't be any law forcing you to go one direction or the other. But what did that also do? It also made sure that the church cannot be controlled by any law passed of the republic. How convenient, right? So people never seem to pay attention to the opposite side of that coin, if you will. So yeah, they're basically complacent, and they're doing so to make sure that the entire system of control stays in place, and that people keep doing their tithing to the church. So that's the long and short of the answer for that. Okay, so to continue, to go back to the doc here, the National Council of Commissioners on Uniform State Laws. Okay, so what they did was they came in and they turned marriage licenses into international private law, so that they could be run through the Hague, and so everybody's a human resource that gets traded across national lines. And of course, then you have the aspects of the passport and so on and so forth about that, because you're passing through ports, because product is passing through ports. So on April 25th, 1938, the Supreme Court overturned the standing precedents for over 150 years concerning common law in the federal government. Now, they didn't necessarily overturn anything. What they were doing was they had to go along with the fact that everybody had basically decided to be under the United States Federal Corporation through the system of pledging. It's not that the common law went anywhere. They can't get rid of it. It's just that you as an infant don't have access to it. So, but anyway, they said there is no federal common law, and Congress has no power to declare substantive rules of common law applicable in a state, whether they be local or general in their nature, they be commercial law or a part of the law of tort. Now, is that incorrect? No, of course it's not. It is correct. But my argument would be that technically there's never been any federal common law. Common law is always an aspect of courts of record on the county level, which the Supreme Court has said that they can't overturn. So if the Supreme Court is telling you that they can't overturn the decisions of a court of record, well, guess who's above who, okay? So he continues, the common law is the foundation of the source of substantive and remedial rights. I would also add unalienable rights, if not our very liberties, which he kind of has reversed there because rights are above liberties, but whatever. See Stephan Treatise on the Principles of Pleading, Introduction, page 23. Hemingway, History of the Common Law Pleadings as Evidence of Growth of Individual Liberty, and Power of the Courts, 5, Alabama Law Journal, so on and so forth. You can find, I think I found all of these in archive.org. So you can just kind of copy and paste any of this information as far as what he has, as far as reference material, and you should be able to find most of it on archive.org. So the members of an association of the bar thereafter formed committees, granted themselves special privileges, immunities, and franchises. franchises, like the state of Wisconsin, right? And held meetings concerning the judicial procedures and further to amend laws, quote, to conform to a trend of judicial decisions or to accomplish similar objectives, close quote, including hodgepodging the jurisdictions of law and equity together, which is known today as one form of action. See Constitution and Bylaws, Article 3, Section 3.3, so on and so forth. The other interesting thing about this that it doesn't mention here, that's what they also say. This quote, one form of action, close quote, is what you'll see as the first thing in the Federal Rules of Civil Procedure. It'll say there is one form of action, and it is the civil action, right? Civil, huh? What? Roman civil law? Excuse me? How do we get there? Well, it's because they're trying to merge these things together and then turn it into Roman civil law. Or you just say, oh, it's all under Roman civil law now. No. If they want to do that on the federal side from the standpoint that there never was technically any federal common law there anyway, for the exception of high prerogative writs like mandamus, quo warranto, habeas, and so on, that's fine. Whatever. Anybody that would be trying to do a common law case on a federal side clearly doesn't know how the system works anyway. But I digress. So anyway, my note is, which in my view cannot nor can never be merged. You can merge the rules if you like, but not the substantive rights that differ in each jurisdiction. This same fight has been going on since 1066. Okay, this whole war between law and equity, or more or less common law and chancery, if you will. So note the enumerated, specified, and distinct jurisdictions established by the ordained Constitution, so on and so forth, were further hodgepodge and fundamentally changed in 1982 to include admiralty jurisdiction, which was once again brought inland. And I believe this is a fundamental bit of evidence for human trafficking and common law theft, which of course it is. The other aspect about maritime admiralty law is that they also said, I believe it was before 82, quite a ways before 1982, is that they said that all insurance contracts are under maritime admiralty law jurisdiction. Okay, so just be aware of that. You just think, oh, well, why do I have to take out insurance on my car, and I'll get fined if I don't have insurance on my, because it's not your car. Okay, you haven't claimed your car. It's not yours. And then furthermore, you go and take out insurance on it. Guess what? Now it's under maritime admiralty. So, bleh. Okay, so continue. Quote, this is a fundamental change necessary to effect a unification of civil and admiralty procedures. So see, they tried to merge law and equity and say, oh, it's civil. And then they're trying to merge civil and admiralty, okay, and then abolish the distinction between actions at law and suits in equity. So then this change would abolish the distinction between civil actions and suits in admiralty. So you see the merge. What the attorneys are trying to do is they're trying to get everything into the law merchant, everything into the filthy way of doing things through Roman civil law, through maritime admiralty, where the judge is a captain sitting up there, and as soon as you get onto his ship, he's God. That's what they want. Well, sorry, but you can't have it that way. Well, not as long as we stand up and say, no, thank you, because it's all about consent. That's another thing. Remember that, too. Court's about two things. Well, government, if you will, meaning to control the mind, government, is all about consent. Court is all about honor and dishonor. So when you get there, who's in honor, who's in dishonor? Have you said that you've withdrawn your consent prior to getting there? Okay. Then who's in honor and who's in dishonor? Who's trying to force someone else into a contract that's not lawful? Who's trying to force someone into doing something of which they never gave consent? It's basically what it comes down to. So to continue, the United States thereafter entered the Second World War, during which time the League of Nations was reinstituted under pretense of the United Nations, and the Bank of International Settlements reinstituted under pretense of the Bretton Woods Agreement. Now, the Bank of International Settlements is what they call the Bankers' Bank. It was set up after the Second World War under the idea that this Bank for International Settlements would be how countries would pay off their war debts, and Germany would pay their debts, and blah, blah, blah. Okay, well, it had nothing to do with that. What it really had to do with is that the Nazis, the ones, the Ashkenazis, the Nazis, the ones that actually won the war, could keep all their profits and disappear into places like South America. Okay, so the German people lost lost the Second World War, but the Nazis won because they got transferred all over the place through Project Paper or Operation Paperclip and so on and so forth. And they got out with their money because what do? They set up all these world banks afterwards, which then ran everything. The International Monetary Fund, I won't get into all that, but that's where you get the aspect of special drawing rights and the fact that they're drawing off of our estates and so on and so forth, but I won't get into all that. So to continue, the United States as a corporate body politic artificial came out of World War II in worse economic shape than when it entered, and in 1950 declared bankruptcy and reorganization. So this is like, again, them going through it. The reorganization is located in Title V, United States Code, annotated. And take note of that, United States Code annotated. You got to get if you want to see the full thing, you got to get the annotated. Go find them. You can find them in law libraries, in state law libraries. The explanation at the beginning of 5 USCA's most informative reading: the Secretary of Treasury was appointed by the receiver in bankruptcy. See a reorganization plan, so on and so forth. The United States went down the road and periodically filed for further reorganization. Things and situations worsened, having done what they were commanded not to do. See Madison's notes, Constitution Convention, so on and so forth. And in 1965, passing the Coinage Act, completely debasing the constitutional coin. That was, I believe, that was Nixon taking away the gold and silver standard under lies. Which I won't get into. At the signing of the Coinage Act, then President Lyndon B. Johnson stated in his press release that, quote, "I have signed this bill before me. We have made the first fundamental change in our coinage in 173 years. The Coinage Act of 1965 supersedes the Act of 1792, and in that act had the title, an act establishing a mint and regulating the coinage of the United States, blah, blah, blah." Close quote. Well, guess what? They don't have any authority to do this. None. Zero. So, if you could hang him now, or if you could hang him posthumously, Johnson needs to be hung. Well, they all do. But from the standpoint of this, you can't directly go and just pass something that is in direct violation of Article 1, Section 10. Can't do it. Now, some people would argue, well, the United States Corporation isn't a state, right? Because it says on Article 1, Section 10 that no state shall, so on and so forth, make anything but gold and silver as tender of payment of debt. And they'd say, the argument being, well, the United States is not a state, it's D.C. Okay, fine. You could make that argument. However, the problem with that argument is that if you took all the assets of a particular situation, meaning like in bankruptcy, when you take the assets of something, you also take the liability of it. So was the power vested from us to them to ever alter nor create anything other than gold and silver as a tender of payment of debt? And the answer is no. So they don't have it anyway. Okay, so either way you look at it, it doesn't work. So to continue, so quote, "I will now sign this bill and make the first change in our coinage system since the 18th century. To those members of Congress who are here on this historic occasion," I just love how they fluff themselves up, "I want to assure you that in making this change from the 18th century, we have no idea of returning to it." Well, thank you very much, Lyndon B. Johnson, for your confession of guilt of treason and common law theft, dare I say, both of which come with the penalty of death, so I don't care, pick one. "It is important to take cognizance of the fact that no constitutional amendment was ever obtained to fundamentally change, amend, abridge, or abolish the constitutional mandates, provisions, or prohibitions, but due to internal and external divisions surrounding the Vietnam War, etc., the usurpation and breach went basically unchallenged and unnoticed by the general public at large, who became a, quote, wealthy man's cannon fodder for cheap source of slave labor," close quote. See Silent Weapons for Quiet Wars. I've posted Silent Weapons for Quiet Wars in Class 2 docs. Anybody wants to go through and read it, you're welcome to do so, to connect up the various different parts of this. So Congress was clearly delegated the power and authority to regulate and maintain the true and inherent, quote, value, close quote, of the coin within the scope and preview of Article 1, Section 8, Clause 5, 6, and Article 1, Section 10, Clause 1, which is what I just mentioned. of the ordained Constitution 1787 and further, under corresponding duty and obligation to maintain said gold and silver coin and foreign coin at and within the necessary and proper, quote, equal weights and measures, close quote. Those exercising the offices of the several states in equal measure knew such de facto transitions were unlawful and unauthorized, but sanctioned, implemented, and enforced the complete debauchement and resulting governmental, social, industrial, economic change in the, quote, de jure states and in the United States of America. See such and such law. I'm not going to read all these, but they're all here and you can all look them up. And were and are now under the delusion that they can do both directly and indirectly what they were absolutely prohibited from doing. See Federalist Papers number 44, Craig versus Missouri, so-and-so. In 1966, Congress, being severely compromised, passed the Federal Tax Lien Act, 1966, by which the entire taxing and monetary system, i.e. essential engine, see Federalist Papers number 31, was placed under the Uniform Commercial Code. So this is where you have the UCC starting to take over everything from the aspect of Roman civil law, the law merchant. The Uniform Commercial Code, the UCC, is, you should think of it as the law merchant on a global scale, okay? And if you want to do more look or research into the law merchant, you can look up the definition. You can also look up actually, I'll post it in class 2 later. And what it is, I believe it's a master's thesis on what was called the Fair Court of St. Ides. Now, the Fair Court, meaning not fair as in equal, but the fair as in, okay, we're having a fair over here and people are coming to sell their wares and yada, yada, yada. And it had its own court. It was a merchant court, of which things were done very quickly from the standpoint of the law merchant. And it explains what the law merchant is, how they run things, and you will essentially see that the law merchant is exactly how they're running courts now. They're all being run through the law merchant in, okay, where's the contract? Okay, okay, if you don't come up and say, yeah, well, where is the contract, or you don't argue the fact that there isn't one, or that some part or clause of the contract is not being upheld, they do everything in the law merchant by presumption, which is an aspect and way of Roman civil law where you're guilty until proven innocent. It's the absolute opposite of common law. So anyway, just to put that out there as far as a good thing to go learn as far as a homework assignment is to learn about the law merchant and the connection and the understanding of the aspect of what that is in the UCC as a global system of that. So to continue, the Uniform Commercial Code was, of course, promulgated by the National Conference of Commissioners on Uniform State Laws in collusion with American Law Institute for the Banking and Business Interests. That's, of course, the American Bar Association, and as I mentioned before, attorneys are your mortal enemy and always will be. They should all be sent back to the City of London, where they came from. So, see Handbook for the National Conference of Commission of State Laws, so-and-so pages. The United States being engaged in numerous United Nation conflicts, including the Korean and Vietnam conflicts, which were under direction of the United Nations and agreeing to foot the bill. See, USCA 28.7J, and not being able to honor their obligations and rehypothecated debt credit openly and publicly, dishonored and disavowed their, quote, notes and, quote, obligations. See 12 USC 44 or 411, i.e., quote, Federal Reserve notes, close quote, through public law, so-and-so, section, da-da-da, to wit. So, what they did was they simply transferred it. They shifted the whole entire system from something that was backed by consideration to something that was completely fake, where you have just double or dual bookkeeping ledger entry. Which, by the way, side note on that, if you want to know the first time that dual bookkeeping entry system for banking ever came into existence, it came from the Venetian black nobility. Okay, it came from the Venetian bankers, the same scumbags that the Vatican placed as trustees under Unum Sanctum, the whole first global testamentary trust where the Pope took the whole entire world, it put the whole entire world into a trust until Jesus Christ returns, and he was going to be the executor, and he made the Venetian black nobility the trustees, and the Christians were then the beneficiaries of said trust. So anyway, that's a little bit of side history. You can find all the rest of that in the timeline, in my timeline doc. So to continue, Section 2, first sentence of Section 15 of the Federal Reserve Act is amended by striking, and the funds provided in this act for the redemption of Federal Reserve notes. Things steadily grew worse. See, so they're removing the capacity to redeem anything, which is exactly what Mandel Edward House said. And very soon, and I'm quoting from the quote, and very soon every American will be required to register their biological property in a national system designed to keep track of the people, and that will operate under the ancient system of pledging. By such methodology, we can compel people to submit to our agenda, which will affect our security as a chargeback for our fiat paper currency. Okay, so basically what they were doing was saying, look, we're going to keep all of their stuff, and it's going to be a benefit to use their fiat paper currency, right? Every American will be forced to register or suffer not being able to work and earn a living. They will be our chattel, and we will hold the security interest over them forever by operation of the law merchant. Under this scheme of secured transactions, Americans, by unknowingly or unwittingly, delivering the bills of lading, that's the birth certificate contracts, to us will be rendered bankrupt and insolvent. And it's also not just that, it's also everything else too. All MSOs and other titles. So when you register these things, that's what they're talking about, delivering the bills of lading. That's what he's saying. To us will be rendered bankrupt and insolvent, forever to remain economic slaves through taxation secured by their pledges. They will be stripped of their right and given a commercial value designed to make us a profit, and they will be none the wiser. For not one man in a million could ever figure out our plans, and if by accident one or two could figure it out, we have in our arsenal plausible deniability. After all, this is the only way to fund government, by floating liens and debt to the registrants, those who register their property, in the form of benefits and privileges. So you're going to daddy, giving him the power of your property, and then he's giving you a benefit to use it. That's called a usufructuary. Okay, you become the usufructuary. This will inevitably reap us huge profits beyond our wildest expectations and leave every American a contributor to this fraud we will call social insurance. It eventually was called Social Security. Without realizing it, every American will insure us for any loss we may incur, and in this manner, every American will unknowingly be our servant, however begrudgingly. The people will become helpless and without any hope of their redemption. Okay, let me read that again. The people will become helpless and without any hope for their redemption. Redemption of what? Their estates. It's the estate that they keep. You have to redeem your estate. That in an estate, the substantive definition of an estate is everything that a man owns in law. It's your amount of interest in something. That's an estate in something. Okay. Also think of it simply as your inheritance, all that you have and own by being a sentient human being with rights and duties that go along with those rights of your body and everything else that you obtain at law. That's what they're saying that they're taking from you. So the people will become helpless and without any hope of their redemption of all of that, and we will employ the high office of the president of our dummy corporation, United States Federal Corporation, to foment this plot against America. That's what that's what Edward Mandel House said, and that's exactly what they're talking about in here in the document regarding the redemption. So when you're talking about redemption, you have to fully understand what it means. Okay, so back to the history doc. Okay, so I was talking about the sentence, the Federal Reserve Act, that it's amended by striking, and the funds provided in this act for the redemption of Federal Reserve notes. So that's where I just want to make the pause, do the redemption thing. Okay, so things steadily grew worse, and on March 28th, 1970, then President Nixon issued proclamation number 3972, declaring a, quote, emergency because the postal employees struck against the de facto government for higher pay due to inflation of the paper bills of credit. See Senate report number so-and-so. Nixon placed the U.S. Postal Department under the control of the Department of Defense. So what happened? The postal employees said, hey, screw you. You're not going to take away our income by hyperinflating this. Now, I don't know if it speaks of it in here. It may, but there was also another case. There was a large case where numerous amounts of judges, both state and federal, filed a suit also during this time, saying, "Hey, you can't do this because you're destroying our income." Right? Of course, the judges didn't strike, but they did do the lawsuit. If it's not in this paper, everybody can just go searching for it because you can find it. It's a massive case that it got buried because no one wants to talk about it, as to the fact that the judges were right, that hey, you can't do this. So they struck and they said, nope, can't do that due to inflation of the paper bills credit. So the system had been faltering for a decade, but the benchmark date of the collapse is put on August 15th, 1971. On this day, President Nixon reversed U.S. international monetary policy by officially declaring the non-convertibility of the U.S. dollar, the Federal Reserve note, into gold. See public law, so-and-so. Okay, not going to read all that, but there you go. On December 21st, 1973, Congress passed Public Law 93-110, amending the Bretton Woods Par Value Modification Act, and reiterated the emergency. And Section 8 of the Bretton Woods Agreement Act of 1945, of which included reports on foreign currency transactions. This further declared in Section 2B that, quote, no provision of any law in effect on the date of enactment of this act, and no rule, regulation, or order under authority of any such law may be construed to prohibit any person from purchasing, holding, selling, or otherwise dealing with gold. Okay. So, that said right there that we can still do whatever we need to do, because they couldn't get rid of that. Okay. But at the same time, they were doing what they were doing on the backside to totally strip any value, any lawful consideration from said notes. Okay, so on January 19th, 1976, Majority S. Holt noted for the record a second, quote, declaration of interdependence, and clearly identified the UN as a communist organization, and that they were seeking both production and monetary control over the Union and people through international organization, promoting the, quote, one world order. See said congressional record, so on and so forth. You can read it there. The socioeconomic situation worsened, as noted in the complaint filed in the U.S. Court of Claims docket number. And by the way, U.S. Court of Claims, I'll just pause here for a moment. Oh, by the way, this is the federal judge case, so it wasn't here. And I have a note here to find this complaint. So the U.S. Court of Claims is the place where you take claims against the United States for monetary damages. So 44 federal judges said, yep, okay, we're going to take you to task here. And they did it in U.S. Court of Claims. Now, as far as I'm concerned, everybody should find this complaint, and everybody should, as far as I'm concerned, file it on your own volition. Because if these judges put this whole case together, trust me, it was written correctly. Okay, so you should file it as an action at law in a court of record, and also file it. Well, you can file. See, here's the thing about the U.S. Court of Claims, which a lot of people don't know. The United States Court of Claims is a court of record. It says that it's a court of record right in their paperwork, and it says it right on their website. So when you do file in the U.S. Court of Claims, it is a common law court. And just know that so that you can control the court. So anyway, to continue, Atkins et al. Versus U.S. Atkins et al. Complained that, as, quote, as a result of inflation, the compensation of federal judges has been substantially diminished each year since 1969, causing direct and continuing monetary harm to plaintiffs. The real value of the, quote, dollar, FRNs, decreased by approximately 34.5% from March 5th, and this is insane, 34.5% from March 15th, 1969 to October 1st, 1975. As a result, plaintiffs have suffered an unconstitutional deprivation of earnings, and in the prayer for relief, which would be your demand for damages for the unconstitutional violations enumerated above, measured in the diminution of his earnings for the entire period since March 9th, 1969. It is quite apparent that the persons holding and enjoying offices of public trust, honor, and or profit knew of the emergent problem, and sought protection for themselves to the damage and injury of the people and children who were classified as a, quote, a club that has many other members, close quote, who, quote, have no remedy, close quote, and knowing that heinous acts had been committed, stated that they, judges, lawyers, would not apply the law, nor would any substantive remedy be applied, checked more or less, but never stopped, until all of us, judges, quote, are dead. Yeah. Such persons fraudulently swore an oath to uphold, defend, and preserve the sovereignty of the nation and the several Republican states of the Union, and breached the duty to protect the people, citizens, and their posterity from fraud, imposition, or vice, and stealthy encroachment. See the court case, Atkins et al. This is something that everybody knew about back then when it happened, and is still going on, and it still needs to be rectified. But to keep this in mind, we could all file the same thing, and it's also another good reason why to just simply start using gold and silver. So that's my little part on that. So to continue, moving and floating exchanging rates or international commerce means private enterprise and not central governments bear the risk of currency fluctuations. Well, wouldn't exactly agree to that, but because it affects everyone. Their idea that it doesn't affect central governments is absolutely ludicrous. Numerous serious debates were held in Congress, including but not limited to Tuesday, July 27th, 1976. See such and such congressional record concerning the international financial institutions and its operations. Representative Ron Paul, chairman of the House Banking Committee, made numerous references to the true practice of the international financial institutions, including but not limited to the conversion of $27 million in gold contributed by the United States as part of its quote quota obligations, close quote, which the International Monetary Fund, Governor Secretary of Treasury, sold. Yeah, under some very questionable terms and concessions. The question is, why didn't somebody just hang him for common law theft, is what I'd like to know. But anyway, to continue. On October 28th, 1977, the passage of Public Law 95-147, 91 Statute 1227 declared most banking institutions, including state banks, be under direction and control of the corporate, quote, governor of the International Monetary Fund. United States Government Manual, so on and so forth, right? So that's when everything got thrown under the IMF. And guess what? The IMF runs everything through what's called special drawing rights. Question is, what are they drawing off of? They're drawing off of our credit, the credit of your state. There was a case years ago with a group of people and basically indicted all of Congress and said that they were guilty of human trafficking and that they were guilty of damage, harm, loss, and injury to us, the people, and because of that, they could no longer have and be a part of the special drawing rights under the International Monetary Fund because of that harm. We then served the International Monetary Fund with a copy of that conclusion, after which 3 days later, the IMF removed Ben Bernanke and Timothy Geithner's name from the IMF website. They were gone. The United States had officially been removed from the International Monetary Fund, the capacity and the ability to have special drawing rights. Now, I do not exactly know what they did, but somehow they finagled it and rolled it around so that it came under another auspice. I don't know again, I don't know exactly what they did, but guess what? I do have the screenshot from the International Monetary Fund showing that they got removed. That I do have still, which I'll post into class too, after class. So, to continue, number 2, Section 10A of the Gold Reserve Act of 1943, so on and so forth, is amended by striking out the phrase, stabilizing the exchange value of the dollar. See the joint resolution entitled Joint Resolution to Ensure Uniform Value to the Coins and Currencies of the United States, approved June 5th, 1933, shall not apply to obligations issued on or after the date of enactment of this section. The international organizations, corporations, and associations had refused to pay their debts and could not pay their debts, and determined that they could pass the loss of their non-redeemable, non-current notes, bonds, and evidences of debt off on others, and thereby crown their fraud with success. This is what they always do. This has happened, I was about to say thousands of times, but hundreds of times across the planet's history. Okay, every single fiat currency system that's ever been tried, and to my knowledge, the date or the amount is somewhere upwards of around 1,652 or something like that tries on this planet. Every single one of them eventually ends in default and crash because it's a math problem. Okay. But what they do is they always scheme and take all of the actual assets, as many of the actual assets as they possibly can, land, resources, property, all of even whole governments for that matter, and then they disappear, they skulk and disappear into the darkness, and no one goes after them and hangs them for what they've been doing. Okay, so case in point, this needs to end. So see letter from the Treasury. Well, I'm not going to read all that, but if you want, there's all the there's all your factual basis of what you can look up. So to continue, in 1980, Congress passed, among other things, Public Law 96-221, providing for the furtherance and expansion of the prolific rehypothecated debt pyramid scheme, and reduced the reserve requirements on, quote, transaction accounts to a minimum of 3% per centum to a maximum of 14% or 14 per centum. See Depository Institutions, Deregulation and Monetary Control Act of 1980. So they just kept going. So this was like their, okay, let's just blow it out the water kind of deal. And then, of course, during that time you had Reaganomics, where you had the ridiculous amount of the interest rates, where the rich were making tremendous amount of money on percentage of interest rates of this fake stuff. So in the United States, neither paper currency nor deposits have value as commodities. Intrinsically, a dollar bill is just a piece of paper, obviously. Deposits are merely book entries. That's where you get your dual bookkeeping entry right there, okay? Deposits are merely book entries. Coins do have some intrinsic value as metal, but generally far less than their face amount. Now, if anybody questions that, go get a modern penny and take a bolt cutter and cut the thing in half. You'll find something very interesting inside, okay? But, all right, to continue. Compare this with the United States Constitution, which says no state shall make anything but gold or silver a tender in payment of debt, and which also says Congress shall have the power to coin money and regulate the value thereof, not some other foreign cartel called the Federal Reserve. Okay, you can't delegate. Once a power is delegated, it cannot be the person who it's delegated to cannot delegate to someone else. Okay, it can only be delegated by that from whence it came, meaning us. So if we want to divest them of the power that has been vested, we have the power to do that. And I think it's about high time we do. So this paragraph was added to the original John B. Nelson document, February 21st, 1992, on July 18th, 1999, to reiterate what was stated previously in the document and to demonstrate firsthand yet another way the Constitution is being usurped, in fact, and in intent. In the absence of legal reserve requirements, banks can build up deposits and increasing loans and investments so long as they keep enough currency on hand to redeem whatever accounts the holders of the deposits want to convert into currency. This unique attribute of the banking business was discovered several centuries ago. At one time, bankers were merely middlemen. They made profit by accepting gold and coins brought to them for safekeeping and lending them to borrowers, but soon they found that the receipts they issued to depositors were being used as money, since whoever held them could go to the banker and exchange them for the actual metallic money. Then bankers, okay, now what this is all getting into, this is the aspect of the goldsmith's tale. If anybody wants to learn the totality of the goldsmith's tale and how this all got started, you should watch the documentary called Money as Debt. You can find that on YouTube. It's Money as Debt, and it's about the original one is about a 45-minute documentary. You should watch the first one. That's the one that I know has the goldsmith's tale in it, which explains everything that they're talking about here, or everything that this gentleman is talking about here, in much more detail. Okay. So the then bankers discovered that they could make loans merely by giving borrowers their promises to pay, which is the banknotes. So what do they do? So the goldsmiths were the Khazarian mob, and they came in and they said, all right, well, we've got these vaults that we have guards on, and so people would come and bring their gold into them, and then they'd give them claim checks. Well, what the bankers were realizing is that when they were wandering around out in the marketplace, that the people were exchanging the claim checks as if they were the money, right? So then the banker said, why don't I just create a whole bunch of claim checks that aren't backed by gold and loan those out and get interest on nothing? Absolute 100% thievery. That's all it is. That's all it's ever been. That's why there were times when the Catholic Church and many other countries banned, absolutely 100% outlawed usury, which is what that is. It's a parasite. That's all they are. So anyway, more notes could be issued than the gold and coin on hand, because only a portion of the notes outstanding would be presented for payment at any one time, meaning presented for the gold that was sitting in the vault. And if everybody came in If everybody would come in and say demand their gold at the same time, that's called a run on the bank. Okay, that's what breaks these thieves in half. Which, of course, not enough metallic money would be kept on hand, of course, to redeem whatever volume of notes was presented for payment. Transaction deposits are the modern counterpart of banknotes. It was a small step from printing notes to making book entries to the credit of borrowers, which the borrowers in turn could, quote, spend by writing checks, thereby printing their own money. Okay, when you write a check, you're creating your own money. That's what the signature is. That's your credit. So you're creating your own credit every time you sign your signature. I don't care if it's on a check. I don't care if it's on a car loan. I don't care if it's on a home loan. Doesn't matter. It's your credit. You created it. It's yours. Now, there is a fairly lengthy and detailed process, which I am not learned in, but I know that it exists, that a gentleman by the name of Gene Keating has been teaching for years regarding how to tell the IRS who has your credit and tell them to go get it back. I can't find anybody that can duplicate it 100% of the time, even though I looked in it for years, which is why I basically put it to the side and said, okay, first off, there's no reason for us to be messing around with the law merchant at all, period. If you claim your estate, that's it. They cannot touch it. It's over. You give me a full accounting, all the credit now. That's it. Then it's over, because you're labeled as a decedent in your IRS master file. And a decedent is not someone who's dead. A decedent is someone who is pending death, meaning you're not alive, you're not dead, you're always pending, because they don't know where you are. And from my understanding, you're also labeled, people have all kinds of other goofy labels in your IRS master file, like as far as your profession is concerned, or your business, like a drug runner or arms dealer, or all of these other various different things that they stick on people's master files to basically launder billions of dollars of money through all of our individual master files. They're using all of our estates as proxies. You got to understand that. You have to understand the system. And you have to know that the only way that this ends, the whole thing ends, is by everyone claiming their estate. Not going to them and saying, oh yeah, by the way, I'm running my estate through commerce, and yeah, I've created credit, and yes, I'm an expert merchant because I'm using the UCC, and yes, I know all the things and all these special laws and whatnot about commerce. I'm not going to go through all that. I mean, if anybody else wants to go through it, be my guest. I mean, I looked through it for a year and a half, and I'm like, there's no way. There's absolutely no way I'm going to bother to go through all that. And I consider myself to be a fairly intelligent human being. And there was no way I was going to be able to run it all the way through and lock it down. So I said, nope, that's not the way to go. Okay, so to continue. Okay, so they're talking about the transaction deposits, so they could spend their own money. So the printing of your own money, which is the aspect of you creating your own credit. So 59 years is not, quote unquote, temporary. It's a permanent state of emergency, which was clearly instituted, formed, and erected within the Union through gross usurpations, abridgments, malfeasance, and breach of legal duties. All of this is what I talk about in the Colonel Edward Mandell House quote, that's posted in class 2. Okay. And my apologies for the poor sound quality on that. We were having my connection wasn't all that good that day, but I go through a lot of this. Okay, all of this stuff that was happening, this usurpation stuff that they're now talking about, that was happening at this time, all started in 33. This is all a continuation of the New Deal, and obviously the Federal Reserve Act. So this is just the more later versions of it. Okay, of the things that they were doing. So breach of legal duties and continual contrivance, misrepresentation, conversion, fluctuations, fraud's the big one. Aravice and the international financial institutions, organizations, corporations, and associations, including the Federal Reserve, but of course not limited to either, their, quote, fiscal and depository agent. This profligate practice has led to such emergency legislation as the Public Debt Limit Balance Budget and Emergency Deficit Control Act of 1985. The government, by becoming a corporator, lays down its sovereignty and takes that of a private citizen. It can exercise no power which is not derived from the corporate charter. See the Bank of the United States versus Planters Bank of Georgia. This is a very important case, by the way, because not only are they explaining in here that, look, guys, you have corporate government, okay? You have a corporation running you. It also explains in the same case another aspect of law, which is the second that the government acts in commerce, they waive their sovereign immunity. I don't care what they're doing. The second they go into the aspect of commerce, they waive sovereign immunity, period. They don't have it. They've never had it since the United States Federal Corporation came into existence. They are a commercial entity, period. They have no sovereign immunity at all. Now, the states may, if they actually decided to act in a de jure fashion, but they don't, so they're under the bus too, okay?
Would that be easily provable by just looking at their numbers up and Dun and Bradstreet?
Sure, you can do that you can certainly do it with the courts. You can lay them out. You can lay the courts flat out because all of the courts are listed under Dun and Bradstreet. Each state is slightly different of how they run them. I know in Iowa that the judicial courts of Iowa are one Dun and Bradstreet number that cover all of the courts. In other states, I think in Illinois, I think they actually do break it up by county, and they're their own little critter. Those are the only two that I know how that work like that for sure. Other states may differ, but anyone, and just to explain to everyone what Spectre and I are talking about here, Dun and Bradstreet. Dun and Bradstreet Credibility Corporation is a very, very, very old corporation. What it is a corporation that basically gives credibility reports of other corporations. So all the well, I shouldn't say all, but I think damn near all the corporations in the world have a Dun and Bradstreet number. You can get their quote unquote their report, their Duns report from Dun and Bradstreet. If you want any of these sons of bitches Dun and Bradstreet number, all you have to do is just register up as a business with Dun and Bradstreet. Just say, yeah, I'm a business. You can be a sole proprietorship, doesn't matter. Just go ahead and register up with Dun & Bradstreet and say, yeah, I'm a business. I'd like a DUNS number. Blah 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 blah. Great, fine, whatever. Doesn't have to be real. Just get in, and then you can look up all the rest of the DUNS numbers on any of the rest of these critters, whether it be literally the state of Illinois has a DUNS number. The counties will have a DUNS number. The
Supreme Court.
The Supreme Court has a DUNS number. Exactly. Canada has a DUNS number. Okay, because Canada is a corporation. It's always been a corporation. It was set up by Mackenzie King, which was Rockefeller's attorney, who was the first prime minister of Canada, and Canada has to register under FCC every year. Okay, the district attorneys for the counties, you'll find under Dun and Bradstreet, it'll say, quote, also traded as Boone County. So you'll have the district attorney's name, and it'll say also traded as Boone County. Okay, that's how they run this shit through Dun and Bradstreet. And then everything's connected through the CAFRs, which is the Comprehensive Annual Financial Reports, which I won't get into. Maybe we'll do that in another class sometime. But that's how everything's connected financially, is through the CAFRs. So you have all the Dun and Bradstreet numbers. They're all corporate. They're all in commerce, all of them. All of this is about contract and consent. That's it. Well, in status. And the fact that when you withdraw consent, you claim your proper status and you claim your state, that's it. You're out. And then you run them over from the standpoint of never deviating from that. You never take a benefit, and you certainly don't play in their game anymore. So anyway, that's the aside for that. So, all right, back to the doc. The government, by becoming a corporator, lays down its sovereignty and takes on that of a private citizen. It can exercise no power which is not derived from the corporate charter. Again, so pay attention to corporate charters as well. The real party in interest is not the de jure, quote, United States of America, close quote, or, quote, state, but, quote, the bank and the fund. The fund being the International Monetary Fund. The acts committed under fraud, force, and seizures are many times done under letters of marque and reprisal, i.e. recapture. Okay, that's what they're doing to you. When a land pirate comes up on you, they are doing and running a letter of marque. That is unconstitutional. Okay? They're saying, oh, I'm coming along and I'm recapturing this property, right, that they're out there to do, when you're not claiming the property that you're traveling around in. Okay? Such principles as fraud and justice never dwell together, that's Wingate's maxims, and, quote, a right of action cannot arise out of fraud. Okay, so that's Broom's maxims, are too high of a thought concept as is due process, just compensation, and justice itself. Honor is earned by honesty and integrity, not under false and fraudulent pretenses, nor will the color of the cloth one wears cover up the usurpations, lies, trickery, and deceits. Of course, they're referring to black robes. When black is fraudulently declared to be white, not all will live in darkness. As assuredly observed by Will Rogers, quote, there are men running governments who shouldn't be allowed to play with matches, as it is applicable today as Jesus' statement about lawyers. The contrived emergency has created numerous abuses and usurpations and abridgments of delegated powers and authority, as stated in Senate Report 93-549. Since March 9th, 1933, and this is, of course, getting into the New Deal, that the United States has been in a state of declared national emergency. In fact, there are now, in effect, 4 presidentially proclaimed states of national emergency. In addition to the national emergency declared by President Roosevelt in 1933, there are also national emergencies proclaimed by Truman during the Korean conflict, and the states of national emergency declared by Nixon, both those times. And from my understanding, they now basically do it every single year. Every single president now basically renews the emergency. Well, what is that allowing them to do? It's allowing them to, well, I shouldn't say allow. It's creating a situation of which they're operating outside the Constitution under the false pretenses that all of this is, quote unquote, an emergency and couldn't just be fixed tomorrow. Okay. These proclamations give force to 470, which I'm sure is a lot higher now, 470 provisions of federal law. These hundreds of statutes delegate to the president extraordinary powers ordinarily exercised by Congress, which affect the lives of American citizens in a host of all-encompassing manners. I would also say American nationals is another way to put it, but yeah. See, the difference between, okay, so there you go. American citizen is a different, well, he wasn't really referring to this in a legal term, but there you go. So American citizens is the de jure term, and then citizen of the United States would be the de facto. Basically, they're infants, okay? In a host of all-encompassing manners, this vast range of powers taken together confer enough authority to rule the country without reference to normal constitutional process. Under the powers delegated by these statutes, the president may seize power, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel, and in a plethora of particular ways, control the lives of all American citizens. The introduction on page 1 begins with a phenomenal declaration, to wit, quote, a majority of the people of the United States have lived all their lives under the emergency rule. For 40 years, freedoms and government procedures guaranteed by the Constitution have, in varying degrees, been abridged by laws brought into force by states of national emergency, close quote. According to the research done in 16 American Jurisprudence, Second Edition, Sections 71 and 82, no emergency justifies a violation of any constitutional provision. Supremacy Clause and separation of powers, it is clearly admitted in Senate Report number 93-549 that abridgment has occurred. The statements heard in the federal and state tribunals on numerous occasions that constitutional arguments are immaterial, quote, frivolous, etc., is based on the concealment, furtherance, and compounding of the frauds and emergency created and sustained by the expatriated aliens of the United Nations and its organizations. And that's exactly what judges will tell you. You go in there and you start arguing constitutional issues in an inferior court of equity that there's no connection to what you are in there to the Constitution. You're an infant. You're property. You're chattel. That's it. You have no protection of the Constitution at all. Unless and until you go through and do the status docs. That's different. Because then you claim your position as a member of the posterity and as one of the people. But that's exactly what they will say. And there's very specific ways in which you need to write court documents so that they can't come over the top of you and say, well, that's frivolous, it's immaterial, that the Constitution has something to do with it. Well, yes, it does. Because what they're saying is that this is all, again, the fair court of St. Ides. This is all commercial and all dealing with contract. As one judge once said, probably more than one federal judge said, that all the people that are in jail are there because they want to be, because they've decided to be, right, by their own volition. Well, isn't that nice? Maybe if someone had a choice or understood what was going on, they would say, no, I'm not going to take that benefit. Thank you very much. But anyway, to continue. The Internal Revenue Service entered into a service agreement with the United States Treasury Department and the Agency for International Development pursuant to Treasury Delegation Order Number 91. The Agency for Internal Development is an international paramilitary operation. Let that sink in for a second. See Department of Army Field Manual, so on and so forth, yada, yada, yada. Okay. And includes such activities as assumption of full or partial executive, legislative, and judicial authority over a country or area. Now, you get all this started, it doesn't start here. It started in the Civil War with the Lieber Code, with Lincoln. So if you want to know where it started there, okay? So read Executive Order 100, which is the Lieber Code, and that's where you get the beginning of this. This is just an expansion of it, okay? Also see agreement between the United Nations and the United States of America regarding the headquarters of the United Nations. It is to be further observed that the agreement, quote-unquote agreement, regarding the headquarters district of the United Nations was not agreed to and is illegally in the country in the first instance, because in this congressional record, they said, guess what? You don't have the right to be here. And they don't, because you know whose land it's sitting on? Rockefellers. Rockefellers donated the United Nations, the land that the United Nations is sitting on, the building. The international organization intents purposes and activities include complete control of, quote, public finance, i.e., quote, control, supervision, and audit of indigenous fiscal resources, budget practices, taxation, expenditures of public funds, currency issues, and banking agencies and affiliates. This, of course, complies with Silent Weapons for Quiet Wars, again, something you want to go read, which is posted, which discloses a declaration of war upon the American people. Okay, that's not a joke. These people have declared war against us a long time ago, and they're continuing to perpetuate it. So, when it comes to the importance of the Second Amendment, you better take this seriously, because they've already declared war. They call it a silent war, or a quiet war, sorry. It's still a war. And they had full intention and to continue to perpetuate it. Now, what certain white hats may be doing in these interesting times in 2020 is anyone's guess. However, that doesn't detract from each and every one of your responsibility to understand all of this and to be prepared for anything and to be ready as a member of the militia, if need be, to defend every single thing that you have. First and foremost, your freedoms. So, to continue, the 1995 edition of the Department of Army Field Manual, FM 41-10, further describes the international, quote, civil affairs operations. At pages 3 and 6, it is admitted that the AID is autonomous and under direction of the International Development Cooperation Agency, and at page 3.8, that the operation is, quote, paramilitary, close quote. The international organization's intents and purposes was to promote, implement, and enforce a dictatorship over finance in the United States. Well, there you go. Okay. Yeah, dictatorship over finance in the United States. So that's what we've been facing ever since. And with that, I think I'll pause here and make a note so that we can come back to this and we can continue the next time Class 2 comes rolling around. And because we're now about 2/3 through the document, so the next time I'll be able to finish it, the last third of this document, to continue out. So with that, I will close it there, and we can then talk amongst ourselves.